Hey there, Stephanie Joy with all things Social Security and the law practice of Joy Disability. Here's a short little segment from our recent live stream Q&A that we have every Wednesday at 1 p.m. Eastern Standard Time on the YouTube channel, All Things Social Security. Enjoy, and if you have any questions, leave them down below in the comments, and I will be sure to get to them. Thanks so much. Bye-bye now.
Hey guys, how is everybody? Shiloh, I see you are here bright and early with 5 million questions. We'll see. We'll get through them, but we'll probably jump around because I don't want to make everyone else not be heard. Are you? Dimple's in the house. Dimple says yes, she can hear us. Okay, good. Guys, you know Shannon Justice of Justice Disability. Shannon's in Kentucky, right? And Shannon, do you see the postings part? The
comments, yeah, I see them.
Yeah. I mean, if you want to put your website in there, so if anyone wanted to reach out to you, feel free. You know, you could just type it right in there. It'll come up on the page. Do you see what I'm saying?
Yeah, it'll let me.
Okay. Anyway, so Shannon's been here before a couple times. So we're gonna share your questions, and you can see maybe a couple different perspectives and stuff like that. All right, so let's go back up to the start. I'm going to start with La Lulu says, "Hi, La Lulu. SSA rents space for contracted medical examiners to conduct the CEs in chiro offices." Yeah, but she said he had a CE with a chiropractor, especially on weekends. Well, that's funny because most of ours are just always in the doctor's office. The regular guy, like he's got his own office. There's no reason for him to go to someone else's office. Could that possibly be the chiro connection? I don't know. I didn't know that SSA did that. That's what you're saying. Are you familiar with that?
Yeah, they do. I don't know that SSA rents a space, but that person may do it. I don't know how they do it, but
the guy that wants to be paid by the SSA. So yeah, he probably doesn't have a big caseload of his own. So he's like, maybe he's a guy starting out on his own, and he's like, I'm going to do SSA work, and then he needs it off. He doesn't even have an office yet because I don't know. That's possible. Yeah, I think I've heard of that. And thinking back, La Lulu, I mean, I haven't heard this, but it stands to reason that let's say there's a rural place that there's no doctors willing, because a doctor has to be willing to do CE exams. And they don't necessarily pay as much as maybe it would be worth the doctor's while or whatever. I wonder if they do take some of the people they do have and say, all right, we're going to rent out in Timbuktu here because these guys, they shouldn't have to drive more than an hour to a CE exam. And so they want to put a CE closer. That would make sense to me because they need to give every claimant the opportunity. And a 3-hour drive is not an opportunity for most disabled people. I mean, 1 hour is hard enough. Merit exposure. Merit exposure says, I reached 100% permanent and total disability yesterday to the VA. Thank you for your service, Merit. And I have a scheduled CE physical exam scheduled for the 13th of April. How can I utilize my recent VA award? Thank you. First of all, well, Shannon, do you have any thoughts? Right.
I'll be honest, I do take those kind of cases, but I hate them. Because
he wants to know how he can utilize his recent VA award.
Good. The printout and the letter that they get, that's your best evidence because most of the time VA doesn't want to do any more treatment than they have to with the people. So there's not as much medical evidence unless they've got a secondary health insurance, to pay for stuff. So it makes it a little bit more complicated. But the letter that it outlines the award and the reasoning behind it, that's the best thing that you can do is send that in.
Well, what I would do, and yes, that obviously goes in because plus it's going to get you on the priority list, at least for timing, for what that's worth, which might not be much. All your VA records should be gotten by the SSA anyway.
Yeah.
Like they do a HITMER and get them, and just make sure that they get every office. Like if you just go to one VA, it's kind of easy to tell. I know there's some like clinics out exterior that like their records don't show up in the VA, even in the veterans access, which is weird. And they don't go through that what is it, JHIE, and it can get a little tricky. So the basis gets in, I think, but then sometimes these tangential things don't. So you just want to make sure all the medical records are going. The award, yes, it's important, so you get that prioritization, and it shows that it doesn't show that you're disabled under the SSA rules, but it shows you got some significant impairments. So that kind of starts, lays a level at least, and then you just got to build it to the rest of it. More stricter definition of You're probably aware of the difference. I know I have a video on that, Merit, where explaining why can I be disabled vet 100% PNC and SSDI denied me. Because one, you have to be able to work, and one, you have to be unable to work at any job that exists in substantial numbers, and the VA doesn't require that. And in fact, you can go out and get a job, and they'll still pay you. So that's it in a nutshell. But make sure that they get all those, every single office you went to. Don't just say like on your 3368 when you apply, the VA in West Virginia or whatever. If you go to different offices, I would definitely put them in there.
Yeah.
Each address separately, because you want to make sure they get all those records, because they don't always all come down on that big HITMR they do. Is my understanding anyway.
Yeah.
I know sometimes people are like, I'm VA, I'm just going to say VA. I'm like, to your own demise. Yeah, that's not going to be helpful for you. You'll find out when denied. So you just got to do your best. Let's see. Michael Ruth says, live in Massachusetts on SSDI. Every time I get a COLA, nice to meet you, Michael, increase, the state deducts it and more. Why aren't the states adjusting so we keep that money? What are you talking about? Are you sure the state? What do you mean the state? The state can't adjust it. You know what he's talking about? Unless some states, most states have a supplement. Nah, that's for SSI. You said SSDI. I scratched that. You're not. It's not getting adjusted for that. Your Medicare costs might go up. So a lot of times we don't actually see the COLA because it actually gets taken by the Medicare premium, because that went up. You follow? And there's usually, for most people, I want to say hold harmless rule. It's where the cost of Medicare premium to disabled people or retired people cannot go up. Even if it goes up more than the COLA, they cannot make you pay for more than what the COLA would cover. It's a little hold harmless. In the end, it's helpful, but it's not still entirely holding it harmless, because now you're not actually getting a COLA for the other things that you have to pay for in life, like gas and food and everything else. And then there's a certain portion of retired people that hold harmless doesn't apply to. If they are not collecting Social Security retirement, but they're on Medicare, that won't apply to them either. I do not believe. You've got to earn to be collecting for it to hold you harmless. You don't know anything about that? There's no state deduction. They can't intervene with Social Security unless you have like a lien or something. Like, did you not pay state taxes or something? So I don't know what you're talking about. You don't know what he's talking about either, Shannon?
I can just assume it's like the insurance, deductible or not, or whatever, that they got to pay for. It raises with COLA too, so it kind of just takes it all away, like you never got it in the first place.
Yeah. All right, I'm going to try to scrim through these and just get to ones with questions. Half Pint wants to know, so you don't think that working through the Ticket to Work program could jeopardize, now you said Ticket to Work program, Half Pint, that's not the same thing as TWP, could jeopardize our SSDI even if it's under the allowed amount. I think people confuse Ticket to Work program with TWP, which is funny because it has a T and a W and a P in it. Do you want to take that, or any thoughts on that?
You probably know more about that than I do.
Okay. Ticket to Work program is what you do when you're trying to get off of SSD by working over SGA. And it's a period of time where they help you do that, and you have certain protections. It's through like designated Ticket to Work providers and stuff like that. That is when you want to get off SSD. You want to be self-sufficient. You don't want it anymore. So clear big difference there. I think what you're referring to is someone that wants to work, but no plan on getting off of SSDI. They know that they're disabled and not able to sustain full-time work. And they want to stay. We have a TWP amount, which is what keeps you in the trial work period. If you don't go over it more than X times, it's a little bit more protection than when you're not, if you're outside the trial work period time. And I have videos on all this, guys, under this playlist. If you're like over TWP, let's say you're totally outside the trial work period. Now you're just working under SGA for the rest of your life, or as long as you can, or whatever. You are subject to CDRs, which everyone is anyway, even if they're not working, and they can consider the kind of work you're doing. So if you're baling hay for a farm and you have a bad back, it's probably not going to look too good. So I'm going to assume when you said Ticket to Work program, you didn't mean that, and you just meant like if you're working under trial work period amount, and you're within your trial work period, you don't think that's going to jeopardize our SSDI when it's under the trial work period. I do not. As a general rule. Shannon, Well, now that I put it that and framed it that way, because she had some miswordings here. Working
long
under
as-
trial work period itself is not going to hurt you. They have to find you medically improved through a CDR, a separate CDR.
Yeah, as long as they stay under the SGA limit, then they should be fine either way. But
Well, except if they're not in their trial work period, the SSA can look at the kind of work they're doing.
yeah,
So when you're in the trial work period, they can't say, well, look at her. She's being a lawyer for 5 hours a week making, it's under trial work period because she don't get paid much. But that kind of shows that she had a cognitive problem before where she couldn't focus and think. And, you know, right now with trial work period, they can't look at the kind of work you're doing to determine that you are no longer disabled. When your trial work period is over because you worked too much over the trial work period amount for too many months, now your barrier is SGA, but now they can do a CDR and they can look at the kind of work you are doing because it's no longer protected by trial work trying. So that's a real important distinction, guys. If your work, that's why it is beautiful to stay under trial work period, not just SGA, particularly if it's going to be higher end work, you know, you're keeping the monies down. But if you're not going to be in trial work period, they can look at how, and it depends again on each fact of each case. Like I just gave an example of someone doing a high end job, who used to do a high end job, making under trial work period, but their impairment was, say, they were in a coma and they had to learn how to think again. Well, now they're clearly learning that, you know what I mean? So their work is actually allowed to be used as evidence. They also have to prove it by the medical evidence, though, too. So anyway, that gets a little complicated, right, guys? Because you have to make sure you're not talking about your ticket to work program, totally different, and then know the difference between trial work period and when you pop out of it, and now you're in your 3 years of extended period of eligibility. And they're like two different animals. Joel's in the house. Hi, Joel. Joel says, good morning. I'm just beginning the SSDI journey. Fun, Joel. Filed initial application 2 weeks ago with spinal stenosis, osteoarthritis as my ailments. I'm 59 years old, using an attorney. My surgeon is filling out the RFC. Awesome. I think you sound like you're in an excellent vocational profile, and you've got the physical problems which keep you in the grid thing. Past relevant work will be important. Obviously, your attorney knows all about this, obviously. So, but you know, do it right, and it might just be what you need. But that, I think the biggest question unspoken is your past relevant work. That's that prong of the grids that can hang an older person, particularly if they had high skilled work, you know, and they have no mental health or cognitive problems at all. Like, no diminution in the ability to concentrate and stuff like that. Joel actually had a question. Sorry, Joel, I hijacked you. Question is, how long can I expect before my case gets going, and when I can expect a determination? I have a ton of medical records, etc. Well, that's a loaded question because it all depends on so many things. Anna, thoughts?
already working on it, and then they'll send you some forms to fill out and request your medical records. Depending on that, whether they'll send you to a CE appointment or not, it's a process. It takes a little bit of time, but they're already working on it.
Right, for sure.
So 2 weeks ago.
Okay, yeah. So as soon as they get it out of the field office, Joel, which sometimes can take a number of weeks, and they connect your lawyer, and sometimes that can take a number of weeks, and they don't always happen at the same time, which is really frustrating. You're going to be at the DDS, and that's when all the medical workup starts. It doesn't start when it's still in the field office. That's like a nothing burger. And we're always trying to encourage them to please process those faster and get it to the DDS. Yeah. And then your attorney, once he's connected, can see your electronic file, and he's going to know what medical evidence was received and put in there by the SSA. If he puts anything in, which you got to be careful about because you don't want to send duplicates. So you try to give the SSA their opportunity, not to mention they pay for it if they do it versus you, the claimant, paying for your medical records, you know? So yeah, you're on your way.